Welcome back to Introduction to the Legal System in Zimbabwe. We continue looking at lesson 2, where we're going to look at sources of law. This is your host, Dr. Filippo Munfumbo. So when we talk about the sources of law in Zimbabwe, we are talking about the constitution, the statutes, the case law, and also the customary law and the common law. So Zimbabwe legal system is derived from various sources, each playing a crucial role in shaping the country's laws and practices. There are primarily four sources of law, although we are going to look at 5 with an extra of common law. So these sources of law work together to shape the legal framework and ensure that justice is served accordingly. So the first source of law that we are going to look at is the Constitution. The Constitution of Zimbabwe is the supreme law of the land, outlining the fundamental rights and also freedoms. It binds every person, natural or justice, including the state and all executive, legislative and judicial institutions and agencies of the government at the same level. So the Constitution is the supreme law, which means that any law that contradicts the Constitution is now and void. So the Constitution upholds the fundamental rights that even mandates you as the citizen of Zimbabwe to be able to sue where you feel your rights are being compromised, and also in any way, whether it is the judicial, it's the executive, or any institution that may inflict the negatively on your rights as a citizen. So there are the key aspects of the Constitution. Number one, its supremacy. So the Constitution is the supreme law, and any law inconsistent with it is void, and to the extent of the inconsistency. So if there is a law that is made which is inconsistent to the Constitution, then the Constitution becomes supreme. The Constitution overrides every law. So if there is a debate which should be right, and the Constitution gives a stand on something, so whatever that other law can say, it cannot be compromised. The Constitution takes the day, and the interpretation is taken from the Constitution. So the Constitution highlights the fundamental rights and freedoms, that is protecting of rights such as the right to life, the right to the personal liberty, freedom from slavery, inhuman and or degrading treatment, and protection of freedom of conscience and religion and expression, assembly and association. Statutes. So there is what is called statutory law, which are mainly called the Acts of Parliament. So the statute law, these are statutes. Statutes are laws passed by Parliament, exercising legislative authority vested in the people of Zimbabwe. So when we talk about the statutes, these are the laws that have been made by us, the citizens of a given country. So these laws are brought in by the people that we elect to represent us in a given constitution, a constituents. And these laws must be consistent with the Constitution and are binding on all citizens. So the Acts of Parliament, these are the acts that have been enshrined in the laws of Zimbabwe. So the key aspects of statutory laws or Acts of Parliament are: number one, laws passed by Parliament, such as the Customary Marriages Act and Administrative or administration of estate act. So there are a lot of acts which talks about lands. It talks about Education Act and all those acts. So those are all called statutory laws. Then there is also what is called legislative authority in the statutory law. The legislative authority, these are Parliament has the power to make laws for the peace, order, and good governance of Zimbabwe. Then there is the other type of law that we have in Zimbabwe. It is called case law. The case law refers to judicial precedents set by courts, particularly superior courts of record. So now, if there is a case that is judicated and that case sets as a precedent, that's why in when we are talking about the authorities in the quotation of cases, we also quote the cases that have been upheld as superior cases. So those cases becomes the law. So the decision of the court can depend on the precedent that has been made in the past and how those cases were judged. So that is what is also called law made by judges or law made by judgment. So decisions of the high courts are binding on lower courts, ensuring consistency in legal interpretation and application. So if the High Court upheld something, then it means that the magistrate court can apply the same principles. So the key aspects of case law or a law made by judges is judicial precedents. So when we talk about judicial precedents, we are talking about decisions of superior courts such as the Supreme Court are binding on lower courts. Then also binding authority, which is the Supreme Court decisions are binding on all inferior courts. Then we have what is called customary law. So customary law consists of customs, practices, and beliefs accepted by a given society as obligatory laws of conduct. So customary law, those are the laws that have been put in place, whereby like traditional laws. So tradition also has the place in the legal system in Zimbabwe. You can be judged by a certain tradition which is under a certain tribe if you are living in that particular society. It is recognized as a source of law in Zimbabwe, provided it is not inconsistent with the constitution. So when you talk about, for example, there are tribes whereby you need to pay the cows if you have broken a certain law in that tradition. So now, you refusing to pay the cows, it can be upheld because it is the law that is applied in that given society. So the key aspects of customary law, number one, it is recognition. Customary law is recognized by constitution and administered by local courts. So the local courts, they administer the customary law. Not only the local courts, also the chiefs in the given society. Then the application of customary law. The customary law applies to matters such as marriage, property, inheritance, and particularly in rural areas. So like laws which comprises of marriages, customary law, we follow customary law. So if you contradict that, you can be punished by using customary law. Then there are what is called limitations in the customary law. Customary law must not be repugnant to natural justice or morality, or incompatible with the written law. So when you talk about the customary law are not written laws. They are not written laws. These are traditions that have been held. So it should not contradict the written law. So whatever judgment, whatever that you are judged from customary law, it should not contradict the moral justice. They should not contradict the rights that you have, the fundamental rights, and it should not contradict the morality of the law. Then we have got what is called, the last three is a common law. So common law in Zimbabwe refers to the unwritten law or non-statutory law, primarily based on Roman Dutch law as applied at the Cape of Good Hope on June 10, 1891. However, the common law at the Cape in 1891 had been heavily influenced by English law, making the common law of Zimbabwe a blend of Anglo-Roman Dutch law. So the common law can also be what has been going on, and where you use the common sense when it comes to making the decision in court. So the court can be able to make a decision where the law, there is no written law that is applying to that particular incident. So when that is applied, you use what is called the common law. So there are certain things that may not be found in the law, in the written law. But if they are not found in the written law, then there is a system, there is a way that the judge will come up with a resolution or with a judgment using what is called the common law. Highlight of sources of law. So when we talk about the highlight of sources of law, the first we have got the Constitution, which is a supreme law taking precedent over all the laws. So when any law that contradicts the Constitution cannot stand. So the Constitution, it becomes the supreme law. Then we have got the statutes and the case law are binding but must be consistent with the Constitution. So the statutes and the case laws, the statutes will say the acts of Parliament and the decision made by the Parliament should be consistent with the Constitution, and all the judgments that are made should be consistent with the Constitution. So this is the second level of the law. Then we talk about customary law. So the customary law is recognized and applied, but may be overridden by statute law. So the customary law can be overridden by the statute law or the Constitution. Then we have got the common law. The common law is it's less, or it is the law that is not that can be overridden by other law, because if for example the judge or the magistrate thinks there is no law that applies to a particular case, then he uses or she uses the common law that can be overridden by these other laws, like the statutes law. So the importance of sources of law. It is understanding the sources of law is crucial for interpreting and applying the law. So you need to understand the sources of law so that you may be able to know, or even when you are interpreting the laws, like what we call administrative law, which is also the statutory law, the constitutional law. So how you interpret these levels of law, it depends on the kind of law, the source of law. So resolving disputes and conflicts It also helps you as a paralegal when it comes to resolving disputes and conflicts, because as a paralegal you have to be vested with the sources of law so that you'll be able to apply them in your work as a paralegal counselor. Then promoting justice, fairness, and equality. So that is that's all about the sources of law. So it is very much important to know and to understand that the Zimbabwe is made up of complex, and it is made up of various sources of law, and these sources include what is called the constitution, the statutory or the administrative laws, the case laws and customary law, and common law. Thank you so much. Once again, this is your host, Dr. Tuipo Mwenfumbo, and let's look at the next class, lesson 3. We'll look at the courts and judicial system in Zimbabwe. Thank you so much, and God bless.